So good morning. Welcome everyone to this webinar today, where I'm joined by my colleagues Poonam Bai, a senior associate, and Nusha Mazaher, an associate from our insurance team, and who both specialize in providing advice to construction professionals and insurers. So, as you can see from the title on the slide, we'll be looking today at issues of causation in a construction context, and whether there are any general rules which can be applied when trying to establish if something has been caused by a faulty product, which may not be covered by professional indemnity insurance, or whether it is actually a design issue, which normally would be. We're going to go through the case law surrounding definitions of products, and we'll talk through what general principles can be gleaned here. We'll then look at the definitions of construction products in the new causes of action against product manufacturers introduced by the Building Safety Act. And finally, we'll cover what potential insurance pot might be available in terms of recoveries. Just a note on housekeeping, please note that whilst this session is being recorded and you can see us, we can't see you. So, what does a professional indemnity policy normally cover? There's going to be many on this webinar who are familiar with the usual arguments between issues of design, which again are typically covered by a professional indemnity insurance policy, and those of workmanship, which are typically excluded from such a policy. It's not something we've got time to go into too much detail today, but workmanship is generally treated as covering decisions left over for the sense of the contractor, like, for example, the type of fixing method used to execute a design provided by another. There are similar exclusions, though, for claims arising from defective products, and where the boundaries between, on the one hand, a design issue, and on the other, a product issue, can seem a bit more blurred. So, first, to try and put in context why this might all be relevant, I've put on the slide a simplified version of what we see as a typical exclusion in a professional indemnity policy. Here you can see that the cover does not extend to any claim which relates to the supply, manufacturer, or installation of a product. Typically as well, there's not always a definition in professional indemnity policies as to what constitutes a product. So at one end, it seems sensible that something like a window pane or a nail is plainly a product in simple terms. At the other end of the scale, though, the supply and production of a building is the ultimate benefit of many construction contracts. So, where then should the line be properly drawn when trying to establish when an issue with a product for insurance purposes is rather an issue to do with how multiple products fit together and is actually one of design? So, Poonam, is there any case law which helps us here?
Thank you, Dan, and good morning to everyone. Thank you for joining us today. And to answer your question, Dan, yes, there is guidance from case law as to what a product is. The first case that we're going to be looking at today is that of Aspen Insurance versus Adana Construction. This is an English Court of Appeal decision. This is a rather unfortunate case where a crane collapsed at King's Dock Mill in Liverpool and gravely injured the crane driver and caused property damage to the surrounding areas. Adana was the subcontractor for works that were carried out, and as part of their works, they had to build the crane base. Now, if you look at my diagram there were dowels which were embedded into the pile cap. These dowels formed the connection between the pile cap and the crane base. The crane base itself was formed by pouring concrete into reinforced steel cages placed on top of the piles. The crane collapsed due to the dowels being not embedded deep enough in the pile cap. This caused a load imbalance and the crane collapsed. Proceedings were commenced against Adana and they sought cover under their policy.
Okay, so question then is, what was the insurance position of the parties?
Yes, so the policy was issued by Aspen to Adana and it covered both product and public liability. Under the section on product liability, there was cover for bodily injury and damage to property in connection with the business or caused by any product. Liability was excluded in connection with the failure of any product to fulfill its intended function.
Okay, so I follow that. So what were the issues then before the court?
Now, there were several issues before the court, but for our purposes today, we are focusing on the issue of what is a product. So in this case, the court had to decide whether the crane base and the dowels were products within the definition of the policy. The insurer, who was seeking to exclude liability under the policy, argued that the crane base and dowels were products and that they were not fit for the intended purpose. Adana, on the other hand, argued that these were not products. It was not part of the range of products that they sold or supplied. In particular, they described the crane base as a lump of concrete that only came into existence when concrete was poured and it was cast on site.
Okay, so what was the decision then of the court in this case?
Yes, so the court held that the crane base was not a product, but the dowels were. Now, if you look at the definition of product under the policy, and I've put it up in the slide, it refers to something that can be manufactured, constructed, installed on site. And while technically the crane base, which was constructed and installed on site, would be a product within this definition, the court was of the view that this was not the result that parties intended to reach. The words product had to have a meaning in the conventional or natural sense, and as an example, the court said a house or a roof or even the crane base did not fall into the category of products when you considered the usual meaning of the word product. The courts went on to say that the hallmark of a product was that it had to be tangible and movable, an item that was transferable from one person to another and not something which came into existence to form part of the land on which it was created. Now, if you apply what the court said to the facts, this is in the next slide, the concrete base was tangible, not movable, and therefore it was not a product. The dowels, on the other hand, tangible, movable, supplied by Adana, they were therefore a product.
Okay, so some sort of principles then that we can draw. What would you say that these are?
Well, to put it simply, the court seems to be saying that context matters, and notwithstanding the technical definition, product has to also have its natural and ordinary meaning, which is to say, it must be something tangible, movable, and capable of being transferred from one person to another. Now, I'm going to go to another case. This is the case of Big B versus Condra. This is an Australian case from Queensland. In this case, the plaintiff was the homeowner whose property suffered severe damage during a storm, and the plaintiff sued the builder for loss. Similar to Adana, there was a policy which provided cover for property damage arising in connection with a product, but excluding liability if the product was not fit for its intended purpose. And as you can see from the definition of product, this was something similar to Adana. It is anything which is manufactured, constructed in the course of the insured's business. In this case, the court applied the principle set out in Adana, which is the next slide. Therefore, while the house was tangible, it was not movable and therefore not a product.
Okay, so some sort of sense of scale then, and perhaps along the lines of a common sense approach, one might hope. But is that always going to be the case?
Unfortunately, no. And you're correct in saying that so far the cases that we have looked at, the judges seem to be taking a common sense approach. And a product is, in deciding what a product is, it's always applied the usual sense of the word. But in the cases that we're going to look at now, there are some surprising decisions. And the first of these cases is Metricon Homes versus Great Lakes Insurance. Now, this is a Victorian Supreme Court decision where Metricon designed, built, and sold a home which turned out to have serious defects due to a design failure. The house had to be demolished, and owners commenced proceedings against Metricon to recover damages. And Metricon sought cover under the policy. Now, similar to Big B and Condra, the court had to consider whether the house was a product. And the definition of product in this case was similar to the clauses in Adana and Big B in that it was defined as any goods or products manufactured or constructed or erected by the insured. Now, if you were following what I had said earlier, you would know the drill. The house is tangible but not movable, therefore it should not be a product. But this was not the case over here. The judge in this case did not agree with the analysis in Adana and found that the house was a product. He was of the view that the definition of product under the policy, which referred to any goods or products being constructed, erected, would mean that the house fell within the definition. He therefore did not think it was necessary to consider the context or natural meaning of the word. Now, this is a very strict application of the definition within the policy. Under contractual interpretation rules, one does require the court to give the words its natural and ordinary meaning, which is what the Court of Appeal tried to do in Adana. However, as you can see here, the court did not consider it necessary to do that, given that the word product was already defined, and the court simply followed the definition. Now, the last case that we're going to be looking at is Liberty Insurance versus Icon Co. And in this case, the decision dealt with whether a 37-story mixed residential and commercial development was a product. In this case, Icon Co. designed a mixed-use development, and completion was in August 2018. By Christmas 2018, there were major cracks appearing, and residents in the development had to be evacuated. The question for consideration was whether the entire 37-story tower was a product. The court considered both the decisions in Matricon Homes and in Adana and held that the policy definition covered a completed building, and therefore this tower was a product.
Okay, so quite a range of decisions then at both ends of the scale. Can we sort of take any sort of general principles then from all of these?
Well, all four cases, as you can see, had a similar definition of the word product. While the English Court of Appeal took a very pragmatic approach when considering what a product was, they gave effect to the intention of parties and to the context of the words. So while they acknowledged that a house or a roof which was constructed could fall within the definition of product as it's set out in the policies, they took a view that this was not the result parties intended. Australian courts seem to take a stricter, narrower approach in interpreting the clause. It falls into the definition and therefore it is covered by the definition. Now, for us here in England, obviously the approach to follow would be Nadana and Bigby. So in conclusion to the question, what is a product? It is something tangible and movable, capable of being transferred from one person to the other.
Okay, thank you, Poonam. So now that we've looked at some of the general principles in respect to products, the question then turns to a recovery. So if you know that an issue has been caused by a product and not by faulty design, how does this affect your ability to recover losses from that product manufacturer? Many on this webinar may insure or be an insured construction professional and may face a claim by a developer where liability may be made out. If the party really at fault, though, is the product manufacturer, how might a recovery action be framed? So, Nusha, what sort of causes of action are we looking at here?
Thanks, Dan, and good morning, everybody. Whilst the insurer's own professional indemnity policy may exclude product liabilities, all isn't lost as there may be potential recovery actions the insured can pursue against the manufacturer of the product or those who have supplied the product. Before the introduction of the Building Safety Act, there was limited recourse against manufacturers of defective construction products or those in breach of construction product regulations. Often, a claim would be limited to breach of contract, but that, of course, is only possible where a contractual relationship exists.
Okay, so how has the position changed then as a result of the Building Safety Act?
Well, sections 148 and 149 introduce a new cause of action for owners or freeholders of residential buildings which are considered to be unfit for habitation, where manufacturers and sellers of construction or cladding products are to be held accountable where the use of a construction or cladding product causes or contributes to a dwelling being unfit for habitation on completion. This applies retrospectively in relation to cladding products or prospectively in relation to all construction products where the relevant products are in breach of regulations or are inherently defective or have been missold. The types of damages that can be recovered include personal injury, damage to property, for example, caused by a fire, or economic loss, which would include the cost of remediation. Mills and Reeve have run various sessions on the Building Safety Act and have discussed in detail how sections 148 and 149 operate. So I won't go into further detail on that today, but there are notes on the slides of various resources in case you wish to go back and watch any of those sessions or read any of the articles. For the purposes of this discussion, we're interested in how the BSA defines a construction or cladding product requirement. So sections 1489 and 1499 of the BSA point to other construction regulations to help define what a cladding or construction product requirement is. Those are on the screen and I won't repeat them because they're fairly lengthy, but the regulations at first glance appear unhelpful and actually provide more confusion than they do assistance with defining what a cladding or construction product is. Schedule 11 of the BSA and the 19 regulations provide no helpful input, and the 2011 regulations, which the definition is on the slide of a construction product, but in short means any product or kit which is produced and placed on the market for incorporation in construction works and the performance of which has an effect on the performance of the construction works. Schedule 2 to the 91 regulations requires the construction product to be suitable for construction works, which as a whole and in their separate parts are fit for their intended use. And Regulation 3.1 of the 91 regulations is again in full on screen and in short requires that a construction product other than a minor part product shall have such characteristics that the works in which it is incorporated, if properly designed and built, satisfy the essential requirements of the relevant regulations. Unfortunately, there isn't a clearly defined benchmark as to what amounts to a construction or cladding product and what the standard to which they comply must be. Overall, the statutory definitions appear to create confusion and collectively make defining what a construction or cladding product actually is quite complicated. As sections 148 and 149 are relatively new, there aren't any cases where the court has had to consider or help shed some light on what a construction or cladding product is defined as, and that may be because of the complexities and uncertainties arising from the drafting of those sections, and so we'll continue to watch this space to see whether any claims are considered by the court.
Okay, so what about alternatives to this sort of route then? What might there be other than the Building Safety Act approach?
Yeah, so a further avenue on this occasion, which may be brought by a contractor, is to potentially bring a claim against a manufacturer for contribution under the Civil Liability Contribution Act.
Okay, thank you. So now that we know how we might frame a cause of action against a product manufacturer, what issues are we going to be facing then in terms of the insurance of those entities and whether it might respond to such a claim?
If a claim is presented to a manufacturer or a supplier of a product, usually they will have taken out product liability cover to indemnify them against actions brought in relation to defective products. This type of cover is often included as part of a larger policy, usually a public liability policy, rather than a standalone policy. Policies will be prescriptive as to the types of loss that are covered, but in general, as I mentioned before, those would be damages the insured is required to pay as a result of damage sustained to property or personal injury, but cover would not usually extend to cover for damage to the defective product itself. While there is no single standard insuring clause in product liability insurance policies, there are a number of common features and requirements which generally define the scope of cover. Again, as I just mentioned, an indemnity is usually provided against all sums which the insured is legally liable to pay by way of damages and claimant's costs, where those damages arise in respect of accidental personal injury, other than that of an employee, or property damage which is caused by the insured's products. A product is typically defined as any product manufactured, sold, supplied, delivered, installed, or constructed by the insured in the course of its business, but only after that product has left the care or custody of the insured. It's not uncommon for these type of insurance policies to also provide an indemnity in respect of defense costs, mitigation costs, and costs of criminal proceedings. However, there are some typical exclusions which may apply, which I'll discuss on the next slide. First, there is loss or damage to or the cost of repairing or replacing a defective product, which are likely to be excluded, and those types of losses are considered to be trade risks and fall outside the scope of the policy. The next is product recall, where costs arising from the insured recalling its products due to safety concerns are excluded. And finally, liability will be excluded where the product fails to perform its intended purpose, but isn't defective per se. Clearly, insurers will, as usual, need to carefully consider any notification that comes in, assess whether the claim falls within the product liability insuring clause, whether any exclusions may apply, or whether it's in fact a design or workmanship issue.
Thanks, Nisha. So to establish then a cause of action against a product manufacturer under the Building Safety Act, the relevant definition involves something placed on the market for incorporation in construction works. So a pretty wide definition. I think it's also helpful to understand that any insurance held by product manufacturers is not likely to extend to damage to the defective product itself. So I'm thinking here in a cladding context of multiple cracked windows on a large scale development. The costs of replacing those windows which are defective may not be recoverable. We've also heard today that for something to be considered a product for the purposes of insurance, it generally has to be tangible, movable, and capable of being transferred from one person to another. Now, plainly, there's always going to be a fair bit of scope for argument here, but hopefully this session's given you an indication of what to look for around this definition. Well, that's all we've got time for today. Thank you for joining us this morning, and please do complete the feedback form, which will be on your screens when we sign off. Feel free to include any topics that you'd like us to consider speaking about. And remember, if you want any more detailed answers to the subjects we touched on this morning, please let us know and we can communicate with you directly by email. In our next session on the 24th of April, we'll be joined by my colleagues Nick Oldham, Neil Shah, and Chloe Poor, and who will be talking about policy allocation in construction claims. Hopefully you'll be able to join us on that occasion, and we here wish you a very good rest of the day and a happy Easter when you get there. Thank you, everyone. Goodbye.